What to do after you create your estate plan. If you hired a good attorney to create your estate plan, you should also get instructions like the ones in this video. What to do after the documents are signed. But as an estate planning attorney, I can tell you this. Most people are confused by the process. After signing, the documents go into a binder, the binder goes onto a shelf, and the plan is never looked at again. Then, decades later, the kids find it while sorting through the paperwork after a parent passes away, and everybody's trying to figure out what they're supposed to do. Hi there, my name is William Ha. I'm a California licensed estate planning attorney. This video is for general information only and not for legal advice. So creating an estate plan is actually a really important first step, but signing the documents alone does not make the plan work. To make sure your estate plan actually carries out your wishes, there are 5 things you need to do. Step 1, fund your trust. The most common mistake I see is that people never fund their trust. People create the trust, but they never put assets into it. The trust only controls assets that are titled in the name of the trust. If your house is still in your personal name, the trust doesn't control it. If your bank or investment accounts are not in the trust also does not control them. Common examples could include your house, your non-retirement bank accounts, brokerage accounts, business interests. Funding isn't a one-time task. Every single time you buy a new asset or open a new account, or when you acquire property, you should ask yourself, should this be in the trust? If it's not in the trust, then the trustee who succeeds you can actually no longer take over control. So creating a trust is a little like buying a suitcase. If you never put anything inside, it looks nice, but it doesn't help you travel. Step number 2, spend time with your trust. Most people actually never read their trust after signing it, and that's actually quite normal. These documents are super long, they're technical, and they can be really overwhelming, right? So you don't need to understand every single word, but you should understand the most important parts of your estate plan. So for example, you want to know who the successor trustee is, when the trust becomes irrevocable, how the assets are distributed at death, and whether or not they're age-based distributions. And at the very least, at a high level, you should know what happens when you pass away and who's ultimately in charge. If something doesn't make sense, that's really not a problem. That's actually reason to schedule a review with an attorney. Step number 3, educate your successor trustees. Your successor trustee is a person who steps in when you can't act or pass away. And here's the reality. Most successor trustees, they feel totally overwhelmed when doing this role. They're grieving, they're scared of making mistakes, and they often don't even know what they're supposed to do. You don't need to give them like a whole full-blown legal seminar, but at the very least, you should tell them that you've named them as trustee and that you want to tell them where the documents are kept, explain your general goals, and that one conversation that could actually save months and years of confusion later. And I see this all the time, where the trustee doesn't know that they're named, they don't know what authority they have, and they're afraid to take action. The little guidance now can prevent the major problem later. Step number 4, consider telling your beneficiaries about the trust. And this step is optional, obviously. I think some people want full transparency, others prefer privacy. There's no single right answer, but here's what I see in real life. Surprises tend to cause conflict. You don't need to share the specific dollar amounts as to who's getting what, but you don't need to hand out copies of the trust. But it can help to let beneficiaries know that a trust exists. You could explain general intentions. You could set expectations. For example, if there were delayed distributions until a certain age, that's better to be discovered now as opposed to later. And clear instructions can prevent additional conflict after death. A good thing to know is that your estate plan is actually not permanent. It's revocable. Typically, you should be reviewing your estate plan every couple of years. A good rule of thumb could be 5 years. So for example, things get changed in life. People get married, people die, people get divorced. These legally significant events, they're actually a good time to review your estate plan. So creating your estate plan it's quite the powerful thing, but creating is only just the beginning. You have to fund your trust. You should understand your documents. You should educate your trustees, and you should communicate with your beneficiaries when it comes to your estate plan. Doing all those things is what turns the paperwork into a plan that actually works. If this video was helpful, please subscribe for more estate planning guidance. Thank you for watching.